We are told that dispute is only in respect to property number 5, which has led to filing of two suits. Appellants did not insist on division of this property by metes and bounds and agreed that respondents shall pay value of share of appellants and thereafter appellants shall forego their claim. It is pursuant thereto value of houses was worked out and the same was acted upon after making payment of three installments by respondents. Appellants also acted upon by handing over possession to respondents. This document has been relied by both the parties in defense also. It does not recognize any new right of parties, but the parties have their own existing rights, and it is only declaration of such rights as also exchange of rights in one or other way. We are of the view that registration of this document was not necessary in respect to property number 5. In any case, under section 9, even an unregistered document was admissible for collateral purpose, particularly when both sides relied on the said document in support of their case as well as in defense of their case to rely on as what was consented between parties. Hence, court below has rightly decreed suit 1 filed by respondents and dismissed suit 2 filed by appellants. Now, coming to the issue number 6, we are of the view that trial court, while considering interest, ought not to have moderated upon rate of interest by directing respondents to pay only 10% simple interest on remaining amount of fourth installment. Instead, rate of interest as provided by mediator ought to have been adhered to. Mediator has directed for payment of interest in the case of fourth installment at the rate of 15% per annum, meaning thereby it was compound interest in respect to last installment of rupees 1 lakhs. In respect to other installments, it only says that the interest shall be 15% per annum. It has not been stated specifically that it shall be payable annually. Hence, in respect to earlier three installments, the rate of interest was only 15% per annum as simple interest, and that has actually been paid by the respondents. In respect to last installment, that is second installment of rupees 1 lakh, interest is payable at the rate of 15% per annum. Words payable annually, particularly in reference to interest, means that interest is calculable annually and it renders the rate of interest to be calculated on compound basis for the reason that interest, if payable annually, will be computed every year, and if not paid, it shall be treated as unpaid amount and entitled to earn interest further. The mention of words payable annually only with respect to fourth installment, that is second installment of rupees 1 lakh, and none mention of these words in respect of earlier installments make it clear that interest herein is different than what it was payable in respect of earlier installments. We find substance in the submission of appellants that in respect of fourth installment, that is second installment of rupees 1 lakh, interest at the rate of 15% was calculable on compound basis. Court below, in taking otherwise view, has erred in law and has further erred in law by going to the extent of moderating interest, which was admitted by parties for the reason that when particular terms and conditions are accepted by the parties, it would not open to any party to wriggle out of one or more conditions and adhere to other conditions. All the conditions have to be taken as a whole or not at all. We therefore hold that 15% interest in respect of unpaid amount of fourth installment is to be computed on compound basis and has to be paid by respondents in order to get sale deed executed by appellants.